Hello students, welcome to this lecture on constitutional philosophy and minority safeguards in India. The Constitution of India embodies a deep moral and political philosophy that balances liberty, equality and fraternity within a plural society. Minority safeguards form a crucial part of this vision. The framers led by Dr. B.R. Ambedkar um, and many stalwarts realized that democracy in India would survive only if minorities felt secure and equal. The constitution thus integrates rights for all while creating special provision to protect cultural, linguistic and religious diversity. These safeguards are not privileges but mechanisms of inclusion, ensuring equal participation. India's constitutional philosophy draws from ancient tradition of tolerance, the Western liberal democratic model, and the bitter experience of partition. By guaranteeing rights to conscience, culture, and education, the Constitution transforms diversity into unity. It establishes secularism as the moral foundation of citizenship and equality as the legal foundation of governance. This lecture explores how India's constitution translates philosophical ideals into concrete minority rights protection through legal guarantees, judicial interpretation, and historical mechanisms that make diversity a constitutional virtue rather than a source of division. The Indian constitution rests on a philosophy of human dignity and justice, drawing inspiration from global human rights movements and Indian reform traditions. It envisions equality within diversity. The framers believed that freedom without social harmony would remain incomplete. Influenced by Western liberal thinkers like John Stuart Mill and by Indian reformers like Ambedkar, Tagore and many other stalwarts, the constitution merges universal human values with indigenous pluralism. The preamble articulates the moral basis of this vision: justice, liberty, equality and fraternity. These values provide the philosophical context for minority protection. The idea is not to privilege any group but to ensure the conditions for peaceful coexistence. The philosophy of constitutionalism binds political power to moral responsibility. It transforms the state into a guarantor of rights rather than an agent of uniformity. By emphasizing human dignity and social balance, the Constitution constructs a framework where every community, large or small, can pursue its culture, faith, and language freely while contributing equally to the nation's collective progress. The preamble acts as the soul of the Indian Constitution and expresses the vision of equality in a plural nation. Words such as justice, liberty, and equality establish a universal foundation for minority safeguards. The phrase fraternity, assuring the dignity of the individual and the unity of the nation, reveals the intention to harmonize group identity with national solidarity. The framers deliberately avoided defining India as a theocratic state or even a secular state. We did not declare any religion to be state religion, despite the fact that India was having more than 80% of Hindu population following a particular religion, plus surrounded by theocratic states on all the sides like Islamic Pakistan on both east and west. Then later on, the East Pakistan became Bangladesh, then Hindu Nepal, etc., etc. And therefore, we were in a position to declare ourselves a theocratic state. But making a religion a state religion is not part of the Sanatan traditions. It has always welcomed minorities with a sense of security, and therefore, following that legacy, Indian constitution makers decided to remain a-religious. No state religion, neither the state is religious nor anti-religious, but a-religious. However, whenever there is a need, state will intervene as and when required for secular activities, social reformation, or social welfare. This we have discussed earlier in our freedom of religion, and we are going to discuss it again. Indian constitution makers envisioned, though they did not use the term secular, but they envisioned a state which will be egalitarian to all the religion, all the faiths, and it will not favor or discriminate against any religion, nor is it going to be officially associated with any religion. Preamble's reference to "we the people" includes minorities as co-founders of the republic, not as dependents seeking tolerance. Equality before law thus implies recognition of diversity within citizenship. This inclusive understanding of democracy ensures that minorities are not merely tolerated but valued participants in the national community. The preamble ideals inform constitutional provisions on religion, language, culture, etc., making them instruments for achieving real and not just formal equality. Hence, the philosophy of pluralism begins with the moral declaration of the preamble itself. Equality and justice form the twin pillars of Indian Constitution. Article 14 guarantees equality before law and equal protection of laws, while Articles 15 and 16 prohibits discrimination based only on religion, race, caste, or place of birth. Yet, the framers recognized that formal equality alone would not eliminate the historical disadvantage, and therefore the Constitution authorizes affirmative action and protective discrimination under 15 Clause 4 and 16 Clause 4 to ensure substantive equality. Minority rights derive from this broader philosophy, protection of the vulnerable to realize justice. Justice in the Indian context means balancing freedom with fairness. Dr. Ambedkar emphasized that the state must actively prevent social and cultural domination. The goal is not uniformity but harmony between groups. Equality thus becomes a living principle that adapts to India's complex diversity. By guaranteeing freedom of religion, culture, and education, the Constitution extends justice beyond economics to dignity and identity. Equality and justice together ensure that minority safeguards strengthen rather than fragment national unity by enabling every citizen to participate fully and confidently in democratic life. Liberty in Indian Constitution extends beyond political freedom to include freedom of thought, belief, and conscience. Articles 25 to 28 guarantee every individual the right to profess, practice, and propagate religion. These provisions are universal and they apply equally to every person, not only citizens, every person, whether belonging to majority or to the minority community. The framers adopted this principle to prevent the tyranny of any dominant faith. Freedom of conscience ensures that personal belief remains beyond the reach of the state. However, this freedom is subject to public order, morality, and health and other fundamental rights, maintaining balance between personal liberty and social harmony. The inclusion of the right to propagate was deliberate, symbolizing India's commitment to genuine pluralism. By protecting religious liberty, the Constitution safeguards minorities' spiritual and cultural autonomy. It also integrates the idea of tolerance into national life. Liberty, when combined with equality and tolerance, forms the ethical foundations of secular democracy. Thus, freedom of conscience in India is not merely an individual right. It is a collective assurance that diversity will remain an enduring feature of the Republic. Fraternity is perhaps the most overlooked yet profound idea in the preamble. It binds liberty and equality through mutual respect and shared responsibility. Dr. Ambedkar called fraternity the social glue of the Constitution. Without it, democracy would remain hollow. Fraternity implies that every citizen, regardless of faith or language, belongs equally to the Indian nation. It demands empathy towards minorities and discourages exclusion. Unlike tolerance, fraternity suggests active solidarity and emotional unity. The Constitution's safeguards for culture, language, and religion thus express fraternity in practice. They transform diversity into belonging. The right to equality would lose meaning without a sense of community and compassion. Fraternity ensures that the majority's power is exercised with sensitivity towards the minority rights and vice versa. Fraternity is not a one sided way, it is reciprocal. It turns the Constitution from a legal document into a moral covenant of the coexistence. In India's plural society, fraternity remains the ethical heart of secularism, sustaining peace and collective progress amid enduring diversity. The Constituent Assembly debates reveal a careful balance between unity and diversity. Members agreed that a secular democracy must guarantee both individual and group freedoms. Dr. Ambedkar, K.M. Munshi, S.C. Mukherjee emphasized that minority rights should secure confidence without creating divisions. The Assembly rejected separate electorates, fearing a reputation of colonial fragmentation, but endorsed cultural and educational autonomy. Ambedkar argued that protection of minorities is the true test of democracy's success. The goal was to ensure participation, not privilege. Nehru explained that equality required more than identical treatment. It required reassurance and inclusion. The debates shaped Article 29 and 30, which protect the rights of minorities to conserve their culture and establish institutions. The Assembly's vision reflected moral conviction that India's unity must rest on voluntary cooperation. Thus, the constitutional design converted historical wounds into an inclusive framework where every community could preserve identity while contributing to national development. Secularism in India means respect and tolerance, which are the two cardinal principles of secularism. It implies equal respect for all religions and not separation between religion and state, or no watertight compartmentalization between religion and state. Normally, the state will remain away from the religion. It will remain irreligious, but if required for any secular activity, social reformation or social welfare, or any economic activity in the public interest, then a state has all the right to intervene. This interpretation emerged directly from the freedom struggle, where the leaders advocated harmony amongst faith. The Constitution does not deny religion but ensures its coexistence under equality. Articles 25 to 28 reflect this philosophy. Secularism guarantees freedom of belief while allowing state intervention for reform and welfare. At the same time, Article 15, 16 completely bans or prohibits discrimination by the state on the basis of caste, creed, sex, and religion only. So, while 25 to 28 preserve freedom of religion directly, Article 15 and 16 preserve our secularism indirectly. It ensures, the Indian model, unlike the Western version, promotes positive engagement with all traditions. It ensures that no religion receives state privilege, yet all enjoy protection, and that no religion is above law and no religion is above rest of the fundamental rights. So, if there is a clash between freedom of religion and other fundamental rights, then it is the other fundamental rights which will be given recognition over freedom of religion. The Supreme Court in S.R. Bomai versus Union of India 1994 declared secularism a basic feature of the Constitution. This principle forms the moral environment for minority safeguards. ensuring impartial governance. Secularism is not hostility to religion but respect for its plurality. In India, it means respect for all the religions, tolerance, and mutual coexistence. It transforms diversity into an ethical strength. In essence, Indian secularism sustains unity through fairness, establishing the foundation upon which constitutional minority protection securely rests. But the freedom of religion is given equally to all the people, not to just one community or not just to the minorities, but it is given to everyone. Constitutional morality, a term often used by Ambedkar, refers to respect for the values embedded in the Constitution above personal or sectarian interests. It requires that both the state and citizens act within the spirit of justice and equality. For minorities, constitutional morality means trust that institutions will uphold impartiality or impartially. It prevents the misuse of majority power, but the freedom of religion and the nature of secularism is a clear warning as well as a freedom for minorities as well, that they should not make undue they should not take undue liberty from the freedom of religion, and their freedom of religion, unlike the freedom of religion of the majority, is also within the boundaries of the law. The Supreme Court in several judgments emphasized that constitutional morality ensures inclusivity in practice. It transforms legal rights into live realities. In a diverse society like India, law alone cannot preserve unity. We need moral commitment. Constitutional morality is the invisible thread linking secularism, equality, and fraternity, as well as one's duties towards other religions and others' freedom. It discourages discrimination and promotes empathy. For minorities, it guarantees that the state's neutrality is not just formal but sincere. The moral discipline distinguishes democracy from majoritarianism. But if you go into the details of freedom of religion, as we have discussed in earlier lectures, one may clearly understand that the freedom of religion has been dealt in constitution with lots of sensitivity, and it is loaded with restriction. In fact, it is the right on which the load of restriction is heaviest, and therefore both majority and minorities have to be very, very careful while exercising freedom of religion. Article 29 and 30 form the constitutional core of minority protection in India. Article 29(1) guarantees any section of the citizens the right to conserve their distinct language, script or culture, while Article 30 Clause 1 allows religious and linguistic minorities to establish and administer educational institutions of their choice. These provisions embody the principle that cultural identity is integral to human dignity. Judicial interpretations in landmark cases such as St. Xavier's College versus State of Gujarat 1974 and TMA Pai Foundation versus State of Karnataka 2002 affirm these rights as fundamental. However, the state retains limited regulatory power to ensure educational standards and fairness. These articles ensures that inclusion does not mean assimilation and that diversity remains a constitutional strength. By guaranteeing autonomy to minority institutions, the Constitution protects freedom of conscience and cultural expression while promoting national integration. And the nature of restrictions on freedom of religion, on both the state as well as the private individuals, are enough an evidence to show that no freedom is absolute and every freedom has to be exercised within the limits of the law. Article 29, 30, along with the freedom of religion from Article 15, 16 to 25 to 28, together transform the idea of tolerance into a legal commitment to equality through respect for cultural plurality. The directive principles of state policy, though non-justiciable, reflect the moral vision of the Constitution. Articles 38, 39, 41, and 46 request the state to promote social and economic justice for all, including minorities. These principles complement fundamental rights by guiding policy towards equality in opportunity and welfare. The framers saw them as instruments to achieve the Constitution's promises of justice and fraternity. For minorities, DPSPs ensures that protection goes beyond law to include material and educational advancements. Programs like minority scholarships, skill development, and community welfare arises from this constitutional philosophy. While not only that minorities are given extra rights with no responsibilities, as one can see that the entire onus of RTE, right to education, under Article 21 is on the majority run institutions, and the minority run institutions are totally exempted from the burden of RTE. These rights embody, these freedoms or these principles embody Ambedkar's belief that political democracy must rest upon social democracy. By linking economic development with equality, the DPSPs operationalize fraternity through policy. Although courts cannot enforce them directly, they influence legislation and governance. Together with fundamental rights, they create a balanced framework. Rights provide legal safeguards, while directive principles provide moral direction, ensuring that minority protection remains a continuous and evolving constitutional responsibility. Judiciary has played a crucial role in interpreting and expanding minority safeguards and at the same time limiting the freedoms interpreted by minority communities as being absolute and uncontrolled. Through progressive judgments, courts have clarified the scope of Articles 25 to 30 and reinforced the secular character of the Constitution. The Supreme Court in Kerala Education Bill 1958 recognized that minority rights are essential for national unity. In TMA Pike 2002 and Islamic Academy of Education 2003, it balanced institutional autonomy with the state's duty to ensure equality education. While at the same time, the court has time and again reinterpreted freedom of religion, wherein the definition of religion means confining the religion to those religious practices which are essential, and the ones which are essential are those mentioned in the scriptures. And all such practices which are not essential, not mentioned in the scriptures, if practiced in the name of religion, are completely declared null and void by the Constitution. The courts have also emphasized that minority rights cannot be isolated from the larger framework of equality and public interest. By ensuring accountability and fairness, the judiciary converts constitutional ideal into living realities. Judicial vigilance thus remains the most effective safeguard of pluralism, but at the same time, the pluralism should not transgress its limits of constitutional morality, respect and tolerance towards other communities, and within the bounds of public order, morality, and health. Secularism, declared a basic feature by the Supreme Court, ensures that religion neither dominates the state nor is suppressed by it. The balance is essential in diverse nations like India. The concept evolved through judicial interpretation and public debates. In S.R. Bomai versus Union of India, 1994, the court held that secularism is a structural principle of the Constitution and part of its basic framework. It guarantees neutrality and equality amongst all religions. This principle does not mean hostility to faith, but protection of freedom for all belief. Secularism also allows reform of practices conflicting with constitutional morality. So, be it triple talaq at one instance, or the practice of halala, or the practice of or the claim for abaya as being essential to Islam, state always have the right to intervene, whether it's an issue of gender equality within any community or reformation of the personal law in favor of gender equality. Minority safeguards operate within the secular framework. The task is to ensure cultural autonomy with respect for others' rights as well as national unity. The politicization of religion has to be prevented by upholding pluralism but also setting up its limits. Secularism in India provides both the philosophical foundation and practical guarantee for minority rights. India's federal structure also supports minority protection by recognizing linguistic and cultural diversity amongst states. The reorganization of states in 1956 on linguistic lines created subnational spaces where regional identities could flourish. Federalism allows minorities concentrated in particular states to exercise self-governance while remaining part of the union. Constitutional provisions such as Articles 345 to 347 enable states to adopt regional languages while protecting linguistic minorities within them. This design prevents domination by a single culture and encourages participation across levels of government. Federalism thus decentralizes diversity, turning it into strength rather than division. Minority institutions can function effectively when both the union and state share responsibility for inclusion. The balance between national unity and state autonomy reflects the Constitution's practical pluralism. Federalism therefore acts as an indirect yet powerful safeguard, ensuring that India's governance respects cultural geography and promotes harmony between local identity and national integration through cooperative democracy. The Constitution recognizes that rights cannot exist without duties. Articles 51A to J list of fundamental duties, reminding citizens to promote harmony, respect diversity, and preserve cultural heritage. For minorities, this framework underscores that protection entails shared responsibility towards national unity. Duties ensure that individual and group rights do not become tools of isolation or conflict. Every community must respect others' beliefs and contribute to collective progress. This moral equilibrium defines constitutional citizenship. The framers envisioned duties as the counterpart of freedom, balancing autonomy with accountability. Courts and educators continue to emphasize this harmony through civic education and public policy. In a plural society, duties strengthen the moral foundation of democracy by preventing rights from turning into privileges. Thus, the ethical balance between rights and duties ensures that minority protection remains rooted in civic responsibilities. It transforms constitutional philosophy into a living practice of cooperation, empathy, and respect across all communities. Let us see the constitutional institutions and minority empowerment. Several constitutional and statutory bodies work to implement the philosophy of equality for minorities. The National Commission for Minorities, established under the 1992 Act, advises the government on policy and safeguards rights under Articles 29 and 30. The National Commission for Minority Educational Institutions ensures the autonomy of minority-run schools and colleges. Similarly, the Ministry of Minority Affairs designs programs for education, employment, and entrepreneurship. These institutions transform constitutional promises into action by addressing grievances, monitoring policies, and recommending reforms. They serve as bridge between citizens and the state, reinforcing trust Their existence also symbolizes that minority protection is a permanent evolving commitment. Effective functioning of these institutions demonstrates India's faith in participatory democracy and constitutional morality. By ensuring accountability and representation, they turn philosophical ideals of justice and fraternity into practical governance. Institutional mechanisms thus make minority empowerment a continuous process embedded in the democratic fabric of India. The constitutional philosophy of minority safeguards reveals India's profound commitment to justice, equality, and fraternity. From the preamble's vision of unity to judicial interpretations affirming secularism, as enshrined in various articles of the Constitution, right from preamble to 15, 16, 25 to 28, and then 29, 30. Every element reinforces pluralism as a natural value. The Constitution transforms diversity from potential conflict into cooperative strength. Minority rights, religious, linguistic, and cultural, reflect a democratic belief that equality requires inclusion, not uniformity. The framers' wisdom ensured that protection does not divide but integrate. Over decades, courts, institutions, and policies have kept this vision alive. Yet, its success depends on constant vigilance and public morality. As Ambedkar warned, constitutional ideals can survive only if practiced in spirit. The enduring message of India's constitutional philosophy is clear. Justice for minorities is justice for all. In protecting diversity, the constitution is continuing or once again implementing the Sanatan legacy of celebrating diversity and, of course, in modern terms, we can say protecting democracy. This vision remains the moral compass of the Republic, guiding India towards a future where every citizen lives with dignity, security, and equal belonging. Thank you.